Courts have ruled that U.S. presidents are immune in civil cases for what they did in office, meaning they can't be sued. But can they be charged with a crime? That's a question that has never been tested. Now, an appellate court has weighed in and decided unanimously former President Donald Trump is not immune and he can be tried for his alleged crimes on January 6th. This after Trump's lawyers tried to set a new standard in court, which seemed to baffle the judges. Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached? Hey, family, Carl is here. There is a moment in every legal battle where the foundation either holds or it crumbles. For Donald Trump, that foundation was always one single argument, one shield that he believed would protect him from everything, every criminal charge, every prosecution. Now, to a major legal setback for Donald Trump, a federal court ruled unanimously that the former president is not immune to prosecution in the federal case, accusing him of trying to overturn the 2020 election. Chief Justice correspondent Pierre Thomas has the story. Good morning, Pierre. George, good morning. Today, the appellate court is rejecting at every level Donald Trump's claims of complete immunity and is saying his trial for alleged election interference can move forward. This morning, a 3-judge panel, 2 appointed by a Democratic president and 1 by a Republican, has issued a blunt, unanimous ruling. Every attempt to hold him accountable for anything he did while occupying the Oval Office. The argument was simple, clean, and absolute. Presidents cannot be prosecuted for what they do in office. Period. Full stop. And if anyone wants to try, they have to impeach first and secure a Senate conviction before a single criminal charge can ever be filed. That was the theory. That was the wall. And Trump's entire legal defense strategy across his biggest federal cases, the election interference case, the January 6th exposure, the obstruction charges, was built entirely on that wall holding firm. His lawyers argued it everywhere. They argued it in trial courts. They argued it in appeals courts. They took it all the way to the Supreme Court. And at every single level, the answer they got back was some version of the same judicial conclusion. No, that wall did not hold. Federal appeals courts have now shredded that argument in published opinions that will be cited for decades. In ruling after ruling, judges have said flatly that Trump has no blanket immunity, that he is now, for criminal purposes, just citizen Trump, and that accepting his arguments would effectively place the presidency above the law and collapse the entire separation of powers. The language in these opinions is not ambiguous. It is not narrow. It is a judicial refusal in black and white to give Trump the one shield that his entire legal strategy depended on. And he is visibly furious about it because the courts he stacked, praised, and publicly counted on to save him are now writing opinions that leave him more legally exposed than he has ever been. Let me take you inside the D.C. Circuit ruling because this is the document that changes everything. A 3-judge panel, unanimously 0 dissents, ruled against Trump's immunity claim in the election interference case. And the language they used is worth sitting with for a moment because it is extraordinary coming from a federal appeals court. The panel wrote that for the purpose of the criminal case, former President Trump has become citizen Trump. He is answerable in court for his conduct. He lacked any lawful discretionary authority to defy federal criminal law in his bid to stay in power. And the court went further, warning that accepting Trump's view of immunity would collapse our system of separated powers by putting the president beyond the reach of all 3 branches of government. That is not a close call on a narrow procedural question. That is not a split ruling with sympathetic partial dissents acknowledging the strength of Trump's arguments. That is a federal appeals court writing unanimously in a published opinion that Trump's core legal argument, the argument his entire defense strategy is built on, would destroy the constitutional structure of American government if accepted. And the court did not hedge on that conclusion. It wrote it directly, clearly, without qualification. That opinion exists in the permanent legal record, and it is one of the most significant judicial statements about presidential criminal accountability in American history. The specific language about citizen Trump is the detail that will follow this entire legal saga, no matter what happens next, because it is a deliberate, precise judicial refusal to treat Trump differently from any other criminal defendant for the purpose of this criminal case. Citizen Trump, not President Trump, not former President Trump carrying special privileges from the office he once held, not a political figure entitled to judicial deference because of who he is and who appointed the judges reviewing his case. Citizen Trump, subject to the same criminal laws, answerable in the same courts, facing the same juries, entitled to no special legal shield that would not be available to any other person accused of the same conduct. That framing was not accidental. Federal judges choose their words with extreme care, especially in major published opinions that will be quoted and analyzed for years. And the D.C. Circuit chose Citizen Trump specifically to make unmistakably, permanently, undeniably clear that the argument Trump was making that ex-presidents carry a lifetime immunity from prosecution for acts committed in office has no basis in law, no support in precedent, and no place in the constitutional framework that the court is sworn to uphold. That phrase is the D.C. Circuit's judicial verdict on the most important legal argument Trump ever made, and it is in the permanent record. Now, the Supreme Court dimension of this story is where it gets more complicated and more politically interesting. After losing in the D.C. Circuit, Trump's team appealed to the Supreme Court. Trump needed the Supreme Court, the court with 3 justices he personally appointed to give him the total shield his legal strategy required. And in Trump versus United States, the High Court did grant broad protection for some official acts. It acknowledged that presidents need some level of immunity to function effectively without fear that every decision will become the basis for a future prosecution by a political opponent. But it did not give Trump the blanket shield he was asking for, not even close. What the Supreme Court created instead was a messy, fact-specific battlefield where some conduct is protected, some conduct is not. And figuring out which is which requires extensive litigation over the specific facts of each specific alleged act. That is not what Trump wanted. Trump wanted a wall that stopped all prosecution at the threshold. What he got instead was a complicated, multi-factor legal framework where prosecutors can still put his conduct on trial. They just have to navigate new doctrinal terrain to establish which specific acts fall outside the protected zone. And that messy middle ground where immunity is partial rather than total, fact-specific rather than categorical, is the specific legal environment in which Trump's biggest criminal cases are now being litigated. It is slower, it is more complicated, but it is not a victory. It is a framework that preserved the prosecution space while making the road to trial harder to navigate. And it is a framework that prosecutors are actively using, one ruling at a time, to build their way toward that trial. The D.C. Circuit opinion is significant for 3 reasons that go beyond the immediate result in this specific case. The first reason is that it was unanimous. Trump's team had argued loudly and repeatedly that the immunity question was at minimum a close legal call, that serious legal minds could reasonably disagree about whether presidents deserve blanket protection from prosecution for acts in office, that the legal history supported their reading, and the courts should at least be divided. A unanimous 3-judge panel saying no with 0 dissents and no partial concurrences hedging on any element of the reasoning is the clearest possible signal that the court viewed Trump's argument as having no serious legal foundation. When federal appeals courts are genuinely divided on a difficult legal question, you get split decisions, concurrences, partial dissents that acknowledge the strength of arguments on both sides. None of that appeared here. The panel agreed completely. No hedging, no partial sympathy for the argument. The immunity claim was rejected completely. The second reason is the separation of powers language, because warning that accepting Trump's immunity theory would collapse the constitutional structure is not standard appellate language about a narrow technical legal dispute. Courts issue that kind of systemic constitutional warning when they believe the argument being made poses a fundamental threat to how American government works, when they believe they are looking at something that goes beyond one case and touches the structure of the republic itself. And the third reason is the Citizen Trump framing, which is a deliberate, carefully worded, permanent judicial statement about the legal status of former presidents in criminal proceedings that will be cited by courts, quoted by scholars, and referenced in constitutional arguments for generations. The no blanket immunity language is the specific judicial conclusion that most directly dismantles Trump's central legal strategy. And it needs to be understood in the context of what Trump was actually arguing, because the argument was far more extreme than most people realized. Trump's team was not just arguing for narrow protection of specific categories of presidential decisions that require some insulation from prosecution to function. They were arguing for a categorical rule that would make every presidential action unreachable by criminal courts unless Congress first impeached and convicted the president for that specific action. Under that theory, a president could allegedly order a crime and face no criminal prosecution whatsoever unless 2/3 of the Senate voted to convict in an impeachment proceeding. Judges raised exactly this scenario during oral arguments, and Trump's lawyers effectively confirmed that under their theory, yes, extreme conduct would be unreachable by criminal law unless Congress acted first. The D.C. Circuit addressed the full scope of that argument and rejected it completely. The court said that Trump lacked any lawful discretionary authority to defy federal criminal law in his bid to stay in power. That specific framing is legally important because it draws a clear line between legitimate exercises of presidential discretion that may deserve some protection and alleged violations of federal criminal law that carry no such protection regardless of the office held by the person committing them. A president exercising discretion within the law gets different legal treatment than a president allegedly breaking the law. And the court said clearly that the second category, which is what Trump was accused of, is not shielded by any version of presidential immunity that the court could recognize as legally valid. The election interference case is where the immunity rulings land with the most direct criminal impact, because that case is specifically about alleged conduct that the D.C. Circuit already addressed in its Citizen Trump ruling. The question in the election interference case is whether Trump's alleged efforts to obstruct the certification of the 2020 election, pressure state officials to find votes that did not exist, and coordinate pressure on Vice President Pence to refuse to certify results constitute protected presidential conduct or criminal conduct for which he can be held accountable, just like any other defendant. The D.C. Circuit already answered the core version of that question directly and unanimously, saying Trump lacked any lawful discretionary authority to defy federal criminal law in those efforts. That conclusion is in the permanent record. The Supreme Court's partial immunity framework requires more fact-specific analysis of which specific alleged acts are protected by official act immunity and which are not. But it did not reverse the D.C. Circuit's core conclusion that unlawful conduct in pursuit of staying in power is not shielded by presidential immunity. The broader pattern of federal courts refusing to give Trump blanket deference is the dimension of this story that most directly undercuts Trump's political narrative about the judiciary. Trump has spent years cultivating the idea that the courts he shaped through his appointments would protect him when it mattered most. He appointed 3 Supreme Court justices. He reshaped significant portions of the federal appeals court system with judges who were vetted by organizations aligned with his political movement. He praised those appointments publicly and repeatedly, holding them up as one of the defining achievements of his first term. And yet, when it actually mattered, when his legal survival depended on those courts giving him the blanket shield his strategy required, the results have not delivered what he needed. Republican-appointed judges have written opinions rejecting his immunity claims. Conservative-leaning panels have ruled against his attempts to fire independent agency heads. The Supreme Court, with 3 Trump-appointed justices, gave him a partial win on immunity, but explicitly refused to give him the total protection his defense strategy depended on. Even a judiciary that has been meaningfully shaped by his appointments is not reliably functioning as a political protection mechanism. Courts apply legal standards, and the legal standards, as multiple courts across multiple jurisdictions have now concluded, do not support the blanket presidential immunity Trump needed. That gap between what Trump publicly promised his base the courts would deliver and what the courts have actually delivered in their written opinions is itself a significant and underreported story about the difference between political loyalty and judicial independence. When you put the D.C. Circuit ruling, the Supreme Court partial immunity framework, the election interference exposure, and the broader judicial pattern together, you get an immunity accountability picture that is far more damaging to Trump's legal position than his public messaging ever acknowledges. His team frames every setback as political persecution. His rallies treat every adverse ruling as proof that the system is rigged against him. But the actual legal record, the published opinions, the unanimous rejections, the Citizen Trump language tells a very different and much more specific story. Trump bet his entire legal survival on one wall: presidential immunity, total blanket, lifelong. The idea that a president cannot be prosecuted for anything done in office without a prior Senate conviction in an impeachment proceeding. That wall is gone. Federal courts have rejected the blanket version of it unanimously. The Supreme Court created a complicated partial framework that leaves significant prosecution space intact and does not give Trump the categorical protection his strategy required. Republican-appointed judges have written opinions refusing to hand Trump the blanket protection he needed. Conservative-leaning panels have ruled against his second-term executive overreach in other contexts, and the language of the immunity opinions, Citizen Trump, no blanket immunity, lacked any lawful discretionary authority, would collapse separated powers, is now permanently embedded in the federal legal record in ways that will shape every subsequent phase of his criminal exposure, regardless of how any individual case ultimately resolves. He came into his legal battles expecting courts to save him. He spent years pointing to his judicial appointments as evidence that he had built a protective legal architecture that would save him when it mattered most. He is now watching those same courts, shaped in meaningful part by his own judicial appointments, write published opinions that say clearly and permanently that no president is above the law, that former presidents face the same criminal accountability as any other citizen, and that the argument Trump built his entire defense around has no basis in American constitutional law. That is not a spinnable outcome. That is not something that goes away with a rally speech or a fundraising email about political persecution. That is a judicial verdict on the foundational premise of his entire legal strategy. Written in published opinions that will be cited by courts, quoted by scholars, and referenced in legal briefs long after the headlines from any single case have moved on. The wall is gone. The shield is shattered. And Citizen Trump now faces the same legal system as everyone.